Good morning, everyone. Just by way of introduction, we're lawyers, so it's a terrible way to start a day. And as I say to most people, hopefully this is the last you ever see of us. Elizabeth and I work at Land & Rogers. It's a reasonably large firm in Australia, offices on the East Coast. We work in what we broadly call the insurance team, but I head up a team of about 40 lawyers that specialize in construction and construction insurance. And it's with that background that we're going to talk today about navigating risks and liability for architects, which is the title of our topic today.
Just running through some slides, and as Charles has said, we act mainly for consultants on projects, often for architects and their insurers, and it's something that we really enjoy. Architects are the great communicators on any project. When it comes time to resolving a problem, it's usually the architect that's in there, getting their hands dirty, talking to all the parties, keeping lines of communication really open, and coming up with solutions. They also keep their documents organised, so it's much preferable to act for architects than builders. Just running through the overview of what we want to talk about today. We're going to look at what we're seeing in the current sort of claim environment, and also talking about a lot of legislative reform that's happened in your space and is affecting all consultants on projects. It's a complex, it is a complex environment and a lot of change, but there are unexpected positives that are coming out of it, and we'll touch on that as well. And that's really our lived experience, not only what we're predicting to happen, but also a lot of cooperation and positive change on projects, not only when things go wrong, but more generally in going to really try to avoid disputes. The third example here is just looking at the practical tools that are available, especially to architects, to identify risks on a project, manage them, prevent them from happening in the first place, but then minimize disputes, claims when they actually do arise. The fourth thing that we're going to talk about, and these are two case examples, it's looking at what we've actually lived through and experienced when something goes wrong, and how we've lent into that bag of tricks that we're talking about, and actually come up and solved a problem, minimized legal costs, kept a project on track. And then another case example of what happens when people don't obey those rules, the tools aren't used, and legal costs are incurred, and we can have a long dispute. This is a timeline that we use regularly. I'm going to ask Charles to talk about the Brookfield multiplex case, because that's really where we start, where we see quite a more relaxed environment, and we start seeing defects coming up and badly managed before we see this massive years of legislative reform to try and fix these problems.
So firstly, this is headed New South Wales. We're both actually from Sydney, so coping with the cold, thank you. But I will also talk about Victorian legislation. But this timeline reflects a decade of incredibly big change in the legislative and risk environment for consultants in Australia altogether. The Brookfield multiplex case was the high point of sort of the common law protecting consultants. The multiplex took that case to the High Court, and in that case, the High Court have essentially found that multiplex as a builder did not owe a common law duty of care to the subsequent owners of a building, a multi-residential and hotel building. And the extrapolation of that decision was that neither did architects, engineers, or any other consultants involved in the industry owe a duty of care to subsequent owners. Now, that was at the beginning of what was been more than a decade now of significant litigation over defective high-rise residential accommodation, especially on the east coast of Australia. Unfortunately, no sooner had that case came out than we had the La Crosse fire down here in Melbourne, and the subsequent investigation, which started highlighting the problem combustible cladding. And this isn't a combustible cladding talk. I know everyone's we've done it over and over. But what that investigation started revealing was the depth of problems in the high-rise construction context. And while we were talking about it on our visits to London, to insurers there, etc., no one was taking much notice until the Grenfell fire happened. And that galvanized not only the industry in the UK, but in particular here in Australia. The politicians had to get involved because it became clear that not only were we dealing with a defective building crisis, we were dealing with a crisis of in fact, dangerous buildings. And you saw then the start of a significant suite of legislative reforms, which in New South Wales probably led the space, apart from Queensland bringing in an act about defective building products. We had in 2018 a very important and significant investigation into the building industry. That report, the Sherlock Ware report, made a significant number of recommendations which have been adopted. And unfortunately, as things turned out, we moved from a cladding crisis into a building crisis. As you'll see there, the Opal and Mascot Towers. If you Google that, they come up probably on still today. Nearly every second news report references back to high-rise residential, which actually had engineering defects. So it wasn't in the architectural space. In New South Wales, we've got to the stage now where at the end of last year, they were going to bring in a completely amended and a new bill that was going to incorporate about 14 other construction or building bills. That hasn't passed and is still back for consultation, but it's likely to pass during the course of 2025. And that will introduce a whole lot of additional regulations. And when I talk shortly about Victoria, a lot of what has been passed in New South Wales, or which is already in the New South Wales system, like having Mr. Chandler, the building commissioner, coming onto a site and closing down a site mid-build, or having architects being called up in front of the building commissioner and having to justify their entire design, including details such as clash 4, 5, 6 months out from the project even going into the ground. It's just a new world in which you're going to be operating, because we've come from a world of deregulation, and we've had to, as a result of the problems that has created, accept that we're moving into a world of more regulation and more oversight.
I think what this slide shows really nicely from the New South Wales perspective is these very high-profile building defects cases arising from 2014 right through to 2018, and then the introduction in 2020 of our Design and Building Practitioners Act. And what that act did was it reversed this decision back in 2014 by the High Court, and it introduced this ongoing duty of care on builders and developers to all future owners of residential properties. What's happened in that act and sort of beyond that timeline, and this has been our lived experience with it in New South Wales, and we'll get into Victoria after, but every time this act is put before the court takes a very, very strict interpretation of it. So this duty of care, nobody knew how far-reaching it would be. It applies to all building professionals, not just builders, which is what happened in Brookfield Multiplex. It applies to every single type of building. And one of the most recent decisions in the High Court at the end of last year, and I always say that when this case was in the Supreme Court of New South Wales, a junior lawyer came and knocked on my door and said, "There's a decision coming down today, and I think this is really big." And it provides that this statutory duty of care, unlike a common law duty of care, is not apportionable. And what that means is that as an architect or as a builder, you can be 100% liable for a loss. And that doesn't matter if it's been caused by somebody else. You can be 100% liable. And that takes us back many, many years to pre-2002, before this proportionate liability sharing of loss was introduced. If we can talk about Victoria just for a moment, and this is really interesting because this bill was only passed in the last couple of days, and this is Victoria following the New South Wales experience. Very strict legislation coming into place. It doesn't introduce this statutory duty of care like we've got in the Design Building Practitioners Act. But I think when this starts progressing through the courts, we'll see again this very strict interpretation of the Act.
Yeah, so like the Design and Building Practitioners Act and the regulations, Victoria's grabbed the bull by the horns and introduced a new act. I was just looking at it on my phone when I was sitting down there. It's, I think, 136 sections. It amends a lot of existing legislation and is going to change the landscape in which you operate as architects in Victoria, just as much as the Design and Building Practitioners Act and all the regulations that underlay that act have changed things quite dramatically in New South Wales, with regulated designs, regulated design practitioners in New South Wales. This being Australia, of course, the states don't do things the same. They will adopt ideas, they will change them. But briefly, what we've got here is, again, like the Design and Building Practitioners Act, the focus of the legislature has been on consumer protection. As Elizabeth was saying earlier, when the Design and Building Practitioners Act came out, everyone was saying, well, this duty of care is only going to be for residential buildings. The court had one look at it and said, no, it applies to every building. So I think the word of caution before getting to the changes is that while there will be no doubt many seminars that you'll go to, there'll be a fair amount in the press, in the trade news about this new act, the Building Legislation Amendment Bioprotections Act, not bill anymore. What we'll see is when the courts have to grapple with these provisions, because they're new provisions, they're new protections, that you'll see the court interpreting this act in a way that might not have been exactly how it is intended. I was also looking at the Hansard record of last week when the final reading speeches, etc. And you see just from the various politicians, the different approaches. There's some politicians, complaining about the onerous obligations that are now going to be placed on developers, through to other politicians saying, well, I've got people in my constituency who really do need the protections. What this bill does is it introduces an entirely new body, the Victorian Building and Plumbing Commission. And that's the new regulator you're going to be dealing with. And that regulator is going to have significant new powers, which I'll get onto shortly. But what it will mean is that the VBA, the body that has been sort of the regulatory body that you've been used to down here dealing with for decades now, is out, and you've got the VBPC. So despite these Orwellian type terms, you've got, in a sense, a very strong regulator with enhanced powers and new obligations on it, and new obligations are going to be imposed on the industry. In addition to that, this act does a lot of other things. Interestingly enough, it moves domestic warranty insurance, which is that insurance that you, as a last resort insurance that you've got across the country. In other words, if you're a homeowner and during the course of the builder goes insolvent and disappears, you've taken out the statutory insurance, and if you can't get any relief from the builder, you can go in the other states. You can go off to this statutory insurer. It's a last resort insurer. In Victoria, it's becoming a first resort insurer. That's very interesting. How it's going to be funded in the long run, I don't know, but that's never been a problem with the Victorian legislature, obviously. It's just going to be a bigger debts that you're all going to carry into the future, and we're all going to carry. But I think that's a positive for consumers. There's a reference to decennial insurance for those who are insurance nuts. It's a type of insurance that's been talked about for more than a decade. The idea of decennial insurance, which is available more freely in Europe and England, is insurance which attaches to the construction work, and it provides a form of long-term defect cover. Can you move on to the next stage a little bit, or are we on it? So this new regulator is effectively a one-stop shop. That's the most important point. And they will deal with this insurance that I've just been talking about. It puts a lot of obligations on developers. adopting an idea from New South Wales. Developers will have to pay a developer bond for anything above 3 stories of 2% of the value. The purpose about that bond is it is a pot of money that can be used by the owners to rectify defects. Now, there are always going to be defects in high-rise residential. They are complex buildings. As you know, everything is built by subcontractors. There are varying levels of skills, and I think there's no developer or builder which won't expect to go back and rectify defects in the defects liability period or beyond. It's not quite clear how much of the legislation or regulations from New South Wales have been adopted. In New South Wales, they're about to push that up to 3%. New South Wales has got a fairly onerous system of inspection that is required to be undertaken before the developer bonds are released. I think that will probably have to work similarly here. This new body is going to have powers to issue rectification orders. Those are incredibly powerful orders. It's got the power to stop buildings being sold. It's got the power to stop units in buildings being sold where there's defects. It's got the power to stop a build. And one can only, one doesn't have to think very hard about what a significant power that is. If a regulator can come in, like David Chandler did in New South Wales a couple of years ago, and stopped a very, very large high-rise multi-building construction work from going ahead because there were defects with the basement and basement supports. I mean, that effectively put that developer under the owner of that developer is fled back to Europe and is unlikely to ever come back to Australia after having been one of the more prolific developers in New South Wales. So it just goes to show that these bodies are going to have teeth, and they are going to employ those powers. It is not going to be a soft regulating environment. We're moving into a much more difficult environment, a much more environment where there's going to be a lot more oversight, and you can expect that, like all bureaucrats and anyone who's given a position of power, they're going to exercise those powers. They're going to test the limits of those powers. And unfortunately, that is going to impact on the architect industry because, as Elizabeth said, you're the meat in the sandwich. You're the interface often between the owners, developers, and the other consultants. The people who've got the soft skills that, or the engineers who are ACT4 probably don't actually necessarily have. And there's going to be a lot of need for you to get involved in scenarios where you're going to have a regulator calling the shots and having to assist owners and developers, in particular developers, get through what could be quite a difficult period.
I think that's enough legislation and case law for 8 o'clock in the morning. We said that we were only going to touch on those aspects, so I'm sorry that we've gotten bogged down in the detail a little bit there. But I think we just wanted to set the scene for what we're dealing with in 2025, and it is a lot of legislative reform. We've put a few other features of the environment on the slide up there, and insolvencies just continue to feature. The headline this morning is that Roberts owes its creditors in its collapse $100 million. I mean, the numbers are actually frightening. And it's not just the dollar amounts, it's also the regularity of it. The April ASIC figures show that insolvency appointments as at April this year were 2,795 in the last 12 months, and that's up 15% from the 2,398 in April last year. I think everyone's still seeing rising costs. It continues to be a pressure point in 2025, and it's just a feature of the environment that we're in. Labour shortages, again, recent stats are showing that we're 90,000 people short in the building industry. Ongoing pressure in terms of the number of falling work. Again, the statistics show that we've got federal and state government goals of building 1.2 million new homes, and on current levels of new home approvals, we're going to come up short by 400,000 on that.
That last little point there, the infrastructure valley of death, is also an important point. We are going through quite a structural problem at the moment with funding from state governments, and that has a massive impact down the line when some of these big projects might grind to a halt. especially in Victoria. The consulting industry is very concerned about that. And we just hope that that's not going to be as disruptive as it may be. We're still talking about 2025. All the doom and gloom we've been talking about. We'll go to the next slide. Oh, sorry. Some of the unexpected positives, Elizabeth.
Yeah, I love unexpected positives. This is my Pollyanna approach on this one. We've talked a lot about our legislative reform, increased powers of regulators, but I think in the end what we're getting is a safer, better regulated industry with fewer defects in buildings, and that's definitely going to be a good thing. We in New South Wales, under the Design Building Practitioners Act, have spoken to a lot of architects who have been involved in an audit process, and this is where the Building Commissioner can step in at approval stage and look at early designs for projects and audit, and it's the architect that turns out running that process as the best informed and the best place to coordinate it. As Charles has said, I mean, the regulator is looking at very, very granular detail, identifying clashes and having them fixed up at a very, very early stage on a project that streets his interest. The costs of that, I mean, an architect, when we spoke to the architectural firm, and it's quite a large practice that ran that audit process, they had 7 dedicated people on it working full time for weeks. Where that cost gets picked up is just an unanswered question at the moment. It's something that will have to be worked through. We've said what it will result in is a higher standard of detailing. It will allow consultants to push for site access on projects where they might generally be kept at an arm's distance by the builder. And we've definitely seen the less reputable operators being moved out of the industry.
That I'd say it includes not only builders, but also some consultants, some very dodgy certifiers, some engineers that got caught in a spider's web, were certifying things, designs done in the light, and they're just not operating anymore because they can't get insurance, some of them, and some of them just will never be able to be re-registered. So it's been some pain, but it's good to get those people out of the industry and allow the people who can do the job properly to do it. We've also seen some positives in terms of the industry working together. As we've noted there's no noticeable uptick in SOPA claims. We've seen, in particular with one very large builder in New South Wales, apartment builder, who's been teetering on the brink of it going into administration because of cash flow problems, where they've directed the developers to make payments directly to the consultants to make sure that money is not caught up in the event that something unforeseen happens, and that's allowed some very big projects to complete. And I think the pressure on that the industry has put on itself has also brought out some of the best in the industry, that we've seen people be more cooperative and working well. And one of the things we talk a lot about, because we do get a lot of our work through insurers, is what's happening in the insurance landscape. It's been a very difficult area for insurers. The professional indemnity market in Australia has been regarded as a high-risk, low-return environment. However, the market has turned, and you're starting to see premiums drop. Fortunately, Australia is now seen as a very good place to do business, and there's a couple of very big, new, important market players. That's insurers coming in from London and from the States who actually want to operate in your field. So there's going to be a broader amount of policy cover out there. That means premiums will go down, and you should be able to get broader cover as well. So that's a positive, and those insurers, when they speak to us, are talking about what the impact of the legislation has been, that they see it as a more regulated environment, therefore lower risk. So that's sort of covers the broad topics we wanted to talk about in terms of the legislative changes, the regulatory changes, and the positive impacts that we're going to see. And they're not going to stop this year. I think we're going to see for the rest of this decade a better industry slowly work its way through, certainly in the residential construction market, and we'll all be operating in a far less litigious, hopefully, not for me actually, but hopefully for you, a far less litigious environment, an environment where things can get done, and you've got a far better oversight. What we wanted to then turn on to is just how to manage risks and a couple of little tools from the toolkit, because what you don't want to see is too much of lawyers like us at the back end. But there are a couple of things that you can do to manage, and this comes from, both of our cases, unfortunately in my case, probably 3 decades of experience, a little bit less for Elizabeth, of acting for consultants in the insurance industry, in the building industry.
And we've tried to keep this as practical as possible. And I'm sure we're probably telling you things that you know, or things that you've heard before. But it's helpful to have just a quick reminder and run through. And the ones that we've got in bold down here behind my head about communicating with your insurers and advisors, and being part of a solution, that they feed into our case examples that we want to take you to. But when you look to your bag of tricks, when something goes wrong, or when you're going through a contract negotiation and your spider senses are going off, there are some red flags. The number of times we hear people say, this was a tough project from the beginning. It was a difficult client. They questioned everything. They tried to beat me down on everything, and even contract negotiations were extremely difficult. That's when you really need to be thinking, is this a project that I want to be involved in? What are the risks going forward? And is it commercially viable?
And why am I being asked to amend my standard terms and conditions? Why is this pressure being put on me? It's something I've used on every other project. It's something my lawyers have looked at, my advisors. It's something my insurers have looked at. That should give you a sense of the environment you're walking into, and an environment you should potentially stay away from.
So turning now to our contracts, we've said keep your scope and your contractual terms tight. Easier said than done. But the number of times that we've seen really helpful detail being nutted out in a reverse brief type process, asking questions and ensuring that a scope doesn't specify aluminium cladding, but it actually specifies the precise product that you actually want to be installed, that you have faith in, and that you're going to feel confident putting forward.
Can I just talk about substitution? It is a massive risk. The case law has demonstrated that the courts will be unforgiving on architects who agree to a substitution, even when the architect might be feeling justified in having looked at a particular product only for its aesthetics. The cases have also demonstrated that the courts will be unforgiving on any consultant in the industry who doesn't know the building code. The days are long gone where an architect could say, I'm not a fire engineer and I didn't know that this was a combustible product, or I didn't know that this product only had these features and not those features. Equally, every other consultant involved in the industry has to know and has to have a good working knowledge of the building code. And substitution is a massive problem. It's a problem that's been highlighted by cladding, but it's a problem across the industry because new and innovative products come in. Builders are always looking for a cheaper alternative, obviously. They value engineer, but they're looking back to you to sign off, to change its spec, sign off on the spec. And unfortunately, the legal risk will often sit with the consultants. The builders might be long gone, and they're not going to have the type of cover, the insurance cover. So substitution is a red flag issue on any project.
We've talked about red flags at contract negotiation. One of the other points up here is to use your contract review and advice services. Your insurers, your brokers, they will often be willing to step in, help you, point you in the right direction if something's causing concern in contract negotiation, or even in the project stage. If something's gone wrong, your insurers are there to help. We've talked about architects being the great communicators, but it's really important to put that into practice, and not just in spoken communications, but also in emails and texts. We've got a great example on an ACP matter where a number of consultants, builder, developer were all involved. It wasn't a residential project; it was a commercial project, and the replacement ACP which was combustible, it was non-compliant, was being suggested between the parties on email, and the builder responded, was the last in the email chain, saying it's been reviewed by the architect and approved. The architect had looked at it for, as Charles said, aesthetic and colour compliance only. But the builder went back and said the architects approved it for BCA compliance, and nobody responded to that email. That was the email that was the silver bullet, the smoking gun in the litigation that we worried about, and we settled the matter as quickly as we could.
No, just use just on that point. But the alternative is that I've currently got a matter. Unfortunately, it is what is a hotel, I suppose. But it's a cladding claim. The architect in that case had been involved in this particular project for many decades, as the casino was developed, and this was a change, and he was absolutely adamant that they needed to use this particular cladding product for aesthetic purposes, but also because it matched the product that was on other parts of the building. The builder came along, wanted to substitute that product for a cheaper product. That seems to be the primary focus, but also there was problems with supply. And to his credit, the architect in this matter wrote to everyone on the project, including the owner, and said, I strongly object to the substitution of this product. This product has been carefully selected by us. We've done our due diligence on it. But if you insist on this other cladding product being put on, so be it. It's on your head. Now, that matter is going to mediation in a couple of months' time. I'm going to rely very, very heavily on that piece of communication. But it would have been very easy for that architect to say, "Oh, look, everyone's agreed it should be substituted. Who am I to stand my ground here?" But he's put something in writing. In that particular case, it wasn't because he was concerned about a fire risk. As it turned out, this product does have some combustible element to it, and that's why it's been changed, and the cladding's been redone. I've also had a case on a very, very high, expensive waterfront property in Sydney, where the architect had specified a certain type of white tile type brick, and because again of supply constraints and cost, the builder changed it, and the architect objected, put it in writing, said to the owner, "Look, this is your call. I don't know this other product. This is a product I'm confident with." The owner agreed to the change. 3 years later, this new brick started yellowing, attracting mold, and there was people with a lot of money who could litigate. And the architect, we walked out of that without paying a cent. So, again, it's difficult. Your job is facilitating as architects. Very often you're the coordinator, but there are times when you need to stand your ground. But the most important thing is just documenting it.
Having the last word, I think, is also important. Two of the tools that we want to talk about is communicating early with your insurers and also being part of the solution. There's no point when something's going wrong, when communications are heating up on a project and there's a problem and fingers of blame are being pointed. There's no point putting your head in the sand. It's really important to notify your insurers straight away. The last thing you want is your insurer suggesting that you were aware of something and you didn't tell them, and it causing a problem for your policy cover down the track. We've said be part of the solution. Again, allowing somebody else, another architect, or we often see it with another engineer, to come in and be part of the solution. They're very easy. It's very easy for them to pick up problems, point the finger of blame. If you're involved in the solution, you can manage how much attention is being focused on you and what you might have done wrong.
Yeah, could I just emphasize, all of you will have cover. You've got brokers. Big firms, there'll be people that you can go to in your firm. Smaller practices, you might be very reliant on your broker. Don't underestimate how much assistance brokers can provide. The good brokers will advise the insurers. The good brokers will put you onto people like us, Most insurers have got free 15-minute, half an hour phone calls. We probably deal with 2 or 3 a week, where we just get queries. I've got this issue. How should I deal with it? Have you seen something like this before? It's effectively free legal advice, but it's also just a guide. It's often you can cut off these problems at the pass by just being open about them and being wide awake to the potential implications if you don't have some assistance. It's painful to have to ask for assistance. I know, as lawyers are probably amongst the worst in the world with our egos, but some early intervention will always provide you a much better outcome than putting your head in the sand.
Our last tool is to keep in mind SOPA and your ability to make payment claims, and that's not necessarily going to prevent a dispute, but at least you're going to get paid. I think we've got some timing deadlines, so we just want to whip through a couple of case examples, and I think it's really helpful to see these tools in practice and where we can make a bad situation better. Charles is going to have the good news story, and I'll have the doom and gloom and the bad news story.
This matter, in fact, got an email yesterday that basically said that this matter is going to be resolved as we had anticipated. This is just a good example of all of those things, those bag of tricks we've talked about. So it's a residential project in Canberra. A large charity who owns this project. The architect had been involved with this particular charity for many years. Development was, as I said, their old age residential. The architect was a lead coordinator. He hired the structural engineer. The project was completed. The old age people moved in. There was then a question raised about this particular structural engineer in relation to another development in Canberra. And it was decided that they should check his calculations for this development. The developer got in an independent engineer, ran the calculations, and it was soon discovered that there were some major problems with the structural design. So you had a live environment, people living in this, and what are you going to now do? This is when he spoke to his broker, Focus Planned, which is the architect institute. We got involved through Focus, which is the insurer, and we immediately engaged with the owners, the developer, and the engineer. When I looked at this in the beginning, it was full of problems. The architect had signed himself up to a contract that was completely unsuitable for professional services, but this is the way it had always been done. He'd retained the engineer, which he shouldn't have ever done. That should have been a direct appointment. There was clearly problems, and this was going to require a lot of work, and it was going to be work in a live environment, and it's going to involve quite a lot of disruption. The risks here were a multi-million dollar claim, and contractually, the scenario would be that a lot of this would land at the feet of the architect. But we engaged with the engineer. The engineering firm was bought out by a big international consultancy. We engaged with them, with their in-house counsel. We got everyone together, lawyers and consultants. That process has been going on for 3 years now. During the course of that process, we had to issue proceedings just in case the process didn't work. But as I said, on Monday, we got an email from the engineers' lawyers to say that they'd agreed to redo the plans, certify the work when it was done, and pay for all of it. There's going to be significant disruption to the business of this old age care facility. They've agreed that they'll absorb those costs, and effectively the architect who was involved daily for months, and then every week he would phone the project manager, he'd phone the owners, he'd phone the engineer, phone me. He's, after all of that time, it's been a lot of effort on his part, but he's walked out with a solution that has not cost him a cent. His insurance record is intact, and it's just a good example of taking a very bad environment, a lot of bad things, but being involved and being part of the solution.
And the legal costs in that one, I don't know if you can see them. I think they fall off down at the very bottom. The legal costs are $70,000, and that's absolutely nothing when you consider the risk that was involved. Particularly when we look at my bad news story, and this still gives me shivers. I lived this matter for 4.5 years. Took me through 2 promotions, and it took us through a pandemic as well. It was a large residential retail development in Sydney with basement car parking, a 12,000 square metre slab. After the project was occupied, and in the DLP period, cracking in the slab was noted, and there was catastrophic or almost catastrophic failure. It was shear punching, very, very large cracking across the soffit of the slab, and urgent emergency make safe and rectification work was put in place. We were for the insurer of the big bad DNC contractor, who actually did a great job. They accepted the problem. They got involved very, very early. They were very much part of the solution, and they were engaging with the other parties. It was very clear. It was a blind Freddy type scenario that there was a problem with the slab design being underdone. And as part of the refining and process in the design of the post-tension slab. The engineer and their insurer would not engage. They helped us come up with the solution and the rectification design, which took 4.5 years to put in place, and we effectively project managed. But they would not help us pay for the costs of that rectification, which involved an entire topping slab across 12,000 square meters and very, very large steel collars on the columns on the underside of the slab. It cost $15 million. The insurers for the structural engineer, after not paying, saw their structural engineer be joined to the proceedings. The structural engineer became insolvent, and the insurers themselves were then brought in. We settled the matter in late 2023. That was after many, many years of expert reports. 1.8 million in legal costs just on our side of the fence. There would have been equal costs incurred by all of the other parties that were involved, including the insurers, as they engaged with experts and barristers. And in the end, the defendants, the insurers of the structural engineering firm, and there were a couple of other parties involved as well, but it was primarily those insurers, wound up paying $12 million back to us. And of course, the contractor had a little bit of fault involved. It wasn't entirely scot-free, but of the $15 million that was spent, $12 million came back after spending 1.8 in legal costs each. And we did everything we could. I mean, we really tried to make that a good news story, and it could have been a good news story, the sharing of the pain early on as we came up with a solution. But people not engaging, taking a hard line, which wasn't clearly not the right thing to do, wound up costing us all a lot of time and a lot of costs, and that's not taking into account at all the cost to the business itself. The 4.5 years of rectification work across the pandemic. This was a site that was affected by the industry shutdowns. The number of times we were in with the builder, digging up documents with their employees, taking witness statements. It was a huge cost to the business and the personnel.
Yeah, I think in common with lawyers, consultants are reluctant to ever admit that they've done anything wrong. And it's understandable in cases that reluctance, however, can get in a life of its own, and it's really important to accept when there's an issue and deal with it. I think that brings us to an end. Am I?
Did
we'll have time.
to wrap it up? Use like well, thank you both so much. Obviously, your time is so valuable to all of us. We actually do have a couple of questions that I think we're already delayed, but I'd like to try and get through them. Even just a couple at least. We've had someone from the audience who has asked, you say there is pressure to change the specification. Isn't part of the problem that there quite often isn't a spec? So just drawings and schedules of products.
Yes, that is going to be a a case. As back-end lawyers, we get to look with the benefit of hindsight at everything, because there's a dispute. And it is often quite frightening how poor the documentation is, and what builders will be prepared to build on. But as the architect, you will be regarded as the lead consultant. If issues go wrong, the people will look at you. And if there is a lack of documentation or lack of specification, then unfortunately, I do think that the onus will be placed on you. The question will be asked why you didn't sort that out, why you didn't ask the questions. I sympathize. Not everyone can build a gold-plated building. Not everyone can be involved in a gold-plated process. But I think it's as long as the question's been asked and documented, that's the way to protect yourself.
And it doesn't necessarily need to be a formal specification. I mean, accompanying drawings, or even, when something occurs to you, when something's problematic, putting it in writing, putting people on notice. It doesn't necessarily need to be a formal spec. And on the other side of the fence, we can see the best, most gold-plated specs in the world, but when they're not complied with and things aren't followed through, they're not worth the paper that they're written on.
Thank you both so much. I can definitely talk on a little bit of that as well. After dealing with architects, quite often the specification is either not required, or that's really not for us to do. But also the specification is written so late in the project. So it's when documentation is due, they're pushing through that specification in the last 2 weeks. So that kind of leads me to my next question. I've noticed that there's a lot of D&C projects that are coming into play now. So what can architects do to minimize the chance of product substitution in those D&C projects?
We do a lot of D&C work. Designer construct contractors have professional indemnity cover. And so we often get in through that route. We do a fair amount of work directly for D&C contractors. We call them the big, bad, and ugly contractors. Well, the first issue is that you're getting often novated, and you've done the preliminary design for the developer. You're getting novated to a builder who has got a completely different view of this, and that is that they want to make a profit from the build. And that's where specification changes often come in. So if your question is, what can you do to lessen your risk? First of all, know the products. There is, again, just to emphasize, it's quite easy to do the research. You have to do the research. If the research or the code mark certificate is not providing you with the comfort that you require, then you have to put that in writing and say, I don't know this product. I can't see the product spec that you've given me is nothing more, for example, than basically a bit of advertising fluff. It doesn't tell me what this product does or doesn't do. It doesn't give me the Australian standards. I can't see where it's been tested. I'm not happy with it. The builder's not going to be happy with you, but that's the way to protect yourself. And it's not just the stuff that you can see. We're dealing in WA with between 7,000 and 10,000 houses that have got leaking pipes, where the cheapest product was used. There was a substituted product in many cases, and we're having to, the government's had to get in, put a fund in place. So product substitution throughout the industry is a problem, and it's a good thing because it's better, newer, more innovative, etc., but it carries with it risks.
Thank you. I've got two more questions. Because we have a couple of manufacturers in the room, and also we are recording this today, it'd be great to hear if you think that there's anything manufacturers can do or suppliers can do to support architects with their documentation.
Well, I think to that point that I've just spoken about, having your documentation, your certification documentation in a clear and ambiguous and well-organized fashion so that an architect and everyone else in the building process can understand and look at that documentation. I mean, that documentation is so important to provide in this new environment. Not only the people involved in the project itself, but now you're going to have regulators and people breathing down your necks who are going to be asking questions about what's been specified in that building. That example that we talked about earlier of the architect firm being called in front of the building commissioner to have the project reviewed, where they went through everything, like literally everything. There's some scuttlebutt that the commission is using AI to, so it's going to they're going to call up issues. If there's a new product, then the architect needs something that you can say, well, we haven't used this before. Here's all the literature. Here's the testing. If it's a product that can be code marked, here's the code mark, etc. It really is incumbent on the people who bring these new products into the market to provide the documentation and comfort, I suppose, to the architect industry.
What the research and development is, and also being present. I mean, there's nothing worse than having a supplier that's based overseas and completely inaccessible, and when something goes wrong, they've disappeared. So just the presence also really helps.
Right, thank you. Feels really logical, but also sometimes just something that we put at the back of our mind, and how important documentation is. The last question is any legislation coming in to help Australian buildings go up more sustainably?
We're probably the wrong people to be asking about that. I mean, all of the states have got, you've got the building code. I suppose it'll need a change at that level, at code level. Obviously, Victoria, the obligations here on making sure your buildings are warm in the winter and cool in the summer is more significant than the obligations here are far more significant than they are in Queensland, for example. But that also attracts problems. I mean, when this cladding crisis evolved, one of the problems that they discovered in Victoria, which is probably absent in the other states, is the insulation problems here, that combustible insulation was used. And everyone's doing it for the right reason. So, that was to make sure that the buildings were more environmentally friendly, less gas, etc., used to heat them. But there's again that risk. Standard polyurethane was used in many cases. That's like a high-risk product if there's a fire. So I'm afraid I'm probably not the best people to answer that, but there are risks associated with...
I want to reinforce, just by way of an anecdote, why we're the worst possible people to ask about this. And I do support sustainable building, and I do support innovation. And unfortunately, we see that that's just where a lot of risk is, and that's where things go wrong. And we've got a wonderful building and a wonderful story, a Sydney commercial tower, which it's very beautiful. It has very fast lifts, and it has a wonderful self-ventilating core, and a roof that opens, and it's naturally ventilated with internal balconies. The law firm that occupies many levels of that building started to use those balconies as office space for its grads, and this beautiful naturally ventilated core was so freezing in winter that the poor grads had to sit out there in those desks with beanies and gloves on, and nobody could understand that those balconies were meant to be transition spaces and never meant for anyone to sit and work an 18-hour day flicking through documents on. But it resulted in a large claim, and the law firm seeking abatement of rent for not being able to use those balconies to torture their grads.
Thank you both. Your time is obviously so valuable. So just in order for us to have a break before our next presentation, we might wrap it up there if that's okay with you.
Fantastic. Thank you so much.